Good evening, ladies and gentlemen. Welcome to the Rates and Lanes podcast. I'm your host, Rico Muhammad. Chuck Snow is out in Saskatchewan or something like that, I believe is where he said he was going. He went fishing for his birthday. Chuck is real secretive. He didn't let us know his birthday was last week, so I think he kind of gave himself a little birthday present to go fishing this week. So he's out doing a little fishing. Hopefully, he catches the big one. If not, we'll welcome him back next week. But tonight, we have our resident legal expert that's joining us tonight, Mr. Hank Seaton. I'm going to go into the DAT Trend Lines newsletter really quickly, and we'll bring Hank on. So let me jump over here to the Trend Lines newsletter really quickly, and we're showing that the average price of diesel fuel has dropped by 3% since last week, showing that the national average price for diesel fuel right now is at $5.27 per gallon. We still have the slow, steady decline in diesel fuel prices, which is a good thing, a really good thing for us out here that's buying, having to pay for our own fuel. Spot rates back to 2018 levels. So dry van line haul rates decreased by less than a penny per mile last week. Dry van load posts on the DAT load board networks dropped over 2020 levels last week, while the number of carriers posting their equipment was the highest level seen in July. In the flatbed sector, equipment post levels reached an all-time high, surpassing the previous record set back in 2019. So, of course, if you're operating strictly on the spot market, you're operating off of supply and demand. And if there's much more supply than there is demand, then you know exactly how you should understand exactly how that is going to affect the spot market rates. But one of the biggest things that you have in your arsenal, if you are operating on the spot market, is the right of refusal. This is how, and I know it's easier said than done. I know, especially when you got bills, we got record high inflation coming down the pike. I understand all of that, so I don't want that to be lost in the conversation. I'm going to share my screen really quickly as we go over the rates nationwide here. So we're starting out with the dry van portion of the report, and as you can see, starting out up in the upper northeastern corridor, we're showing that the average outbound spot market rate checks in at $2.44 per mile. Dropping down to that mid-Atlantic and southeastern states, we're showing an average outbound spot market rate for dry vans at $2.80 per mile. Moving up into the Midwest, that average outbound spot market rate checks in at $2.78 per mile. Moving down to the south central region of the United States, that spot market rate is $2.74 per mile. And coming out of the West Coast, we're showing an average outbound spot market rate for dry vans at $2.63 per mile. Shifting gears, jumping over to the skateboard or flatbed portion of the report, coming out of that upper northeastern corridor, that average rate per mile on the spot market is $3.36 per mile. Moving out of the southeast and mid-Atlantic states, that average outbound rate is at $3.77 per mile. Jumping back up into the Midwest, that average outbound rate is $3.64. Moving out of the South Central region, we're showing $3.46. And wrapping up, coming out of the West Coast, we're showing an average outbound rate of $2.97 per mile. Jumping over to the reefer or temperature control portion of the report, we're showing an average outbound spot market rate coming out of the Northeast of $2.62 for reefers. Moving down to the mid-Atlantic and southeastern states, we're showing an average outbound rate of $3.08. And climbing back up in that Midwest area, we're showing average outbound rates for reefers at $3.14. Moving down to the South Central region, we're showing average outbound rates for reefers at $3.16. And wrapping up, coming out of the West Coast, we're showing an average outbound spot market rate at $3.10 per mile. And without any further ado, I'm still sharing my screen. I'm giving you a screenshot of Hank Seaton's website. If you have any questions, if you would like to get in contact with Hank, there's a wealth of information that he has available over on his website as well. You guys can go over there, check him out. You can also order the book right there. If you see the little link right there, order the book. You can order the book of Hank's book right there on that website as well. Um, let's see. We're going to stop sharing the screen. And the book I'm referring to, mine's a little beat up, but it's this book right here, Rules of the Road. As I've always said, this is kind of like the trucking industry Bible. There's a lot of information, a gang of information that is covered in this book. This is this new book that Hank got. The first book that he had, it was a kind of a little bit smaller one, but this one is quite significant. Covers a lot of stuff in detail. You got some sample bill of ladings that are in here that you can go off of. You also have some sample um, uh, broker contracts, shipper contracts. All that stuff is right there in the book. So it's a wealth of information. And with that being said, I want to welcome our resident legal expert, gracious enough to join us on a monthly basis, Mr. Hank Seaton. Good evening, Hank. How are you?
Good evening, Rico.
All right. So how are you? How are you feeling this evening?
It's been a busy week. A lot of things happening, and I guess if you're busy, you're blessed, right?
That's hey, that's always a good thing. So Hank, last time we talked a little bit about dispatch services. We kind of touched a little bit on AB5. The AB5 issue looks like it's kind of hit it really has hit a tremendous wall out in California and everything right now. So I know you keep abreast. You definitely have the pulse of all these different things going on across the country. Share with us some more insight on how things are turning out there in California or nationwide as far as that concerned. But the AB5 is definitely a California issue.
I think the repercussions of AB5 is causing more nervousness among carriers than anything I've seen in the past few years. Uh, a lot of folks were banking on the fact that it's too crazy to believe it just won't happen. And when it came through the Ninth Circuit, they said, "Oh well, uh, there's a split in the circuits. The Supreme Court will handle it. We don't know how to handle it ourselves. We don't believe it'll happen." Well, now it has happened. The effect of the court's decision not to hear the appeal is to put in place California AB5, and there's every indication that the state of California will enforce it with a vengeance. Let me just review that. I know people hear AB5 and they don't really understand what it's all about. Uh, some largely blue state legislatures and labor movement has adopted a new standard for determining across industries what constitutes an independent contractor. At the federal level, there's always been a control test. Most states have a carve out for owner operators. There's a small business exception, but somehow the trucking industry got looped together with every other industry where people didn't even have a skin in the game and where there were obviously abuses. The effect of that is the passage of what everybody knows as AB5. Just to simplify it, the B prong of this test says that if the putative independent contractor is in the same trade or business as the motor carrier or whoever hires him, then he's got to be considered as an employee and not an independent contractor. That very premise is absolutely crazy. I'm a lawyer. Uh, if I do legal work for a trucking company, I'm eminently involved in the trucking company, but I get paid as an independent contractor. Same is true for uh, doctors who work in an emergency room. They're treated
Right.
as independent contractors. The same thing happens for accountants who are outhouse accountants working permanently for major companies. They get the benefits of being their own independent businessman and filing their own taxes. Somehow, the nanny state people have decided that only in trucking and in traditional 9 to 5 jobs is a individual denied the ability to be a small businessman. So what we've got is this B prong, which, depending upon how you interpret it, says that drivers who own their own rigs and who want to be independent contractors are losing that right because the state of California knows better. And as independent contractors, they don't get nanny state benefits, i.e., they don't have mandatory workman's comp, i.e., they don't have access to a whole host of California regulations, which most independent contractors say takes away the entrepreneurial uh, opportunity. It's kind of like I've told people it's kind of like Dolly Parton's 9 to 5. What a way to make a living! There's a whole group of people who are enterprising truck drivers who don't want a 9 to 5. They want to set their own hours, work when they want to work, uh, uh, get a truck, maybe add 2 or 3 trucks. But all of that's part of being a businessman. I know I'm preaching to the choir to Rico about this, but I assume that most of our listeners are in a similar situation.
I hope so. And I just want, as a little bit of a housekeeping note, I just dropped, if you want to join us, if you would like to join us via video, if you'd like to come on board, ask a question or join in the discussion, I just dropped the link in the chat. If you click on that link, hopefully it'll bring you up, and you can also join us via video. If you just have a question, or if you want to get a question in, you can just type your question in the chat, and we'll definitely make sure that we try to address your question or concerns as we go throughout the show tonight.
Yeah,
So,
I would welcome you doing that because I'd like for this to be interactive as possible and be sure that somewhere in my legalese we don't lose the import of what's being said here. So you have now got the enforcement of AB 5 in California. That means that there are teams of investigators out to file what they would consider to be scuffles. That's a term for people who are trying to avoid taxes. And we, just as we know there ought to be laws, but how those laws are enforced, whether they're punitive or accretive, makes a difference. I think the trucking industry's uh, issue really is not just that they're all well-meaning people who believe the government should be here to help you, that it's also got a political agenda behind it, which is primarily the idea that the middle class is defined by people who uh, who are organized and represented in a labor forum. And that's probably one of the reasons, actually, that there wasn't a carve out for trucking in the legislation. It's very clear that in trucking, there's traditionally been a large alliance between the current administration and and the Teamsters, and the thought is that politically, AB 5 will ultimately inure to the benefit of the Teamsters. So, I
here's a quick question, Hank, because I know AB 5, that, and correct me if I'm incorrect on this, but the AB 5 issue is mainly a California state issue. Is that correct?
uh, in its implementation now, it is. But unfortunately, it is the precursor of what is to come. New York, New Jersey, Illinois all have uh, pending similar legislation. So it may take a while to get there, but AB 5 is the first implementation. It's
So that
it, it's the time that there is no hope. The other thing that you've got to realize is that the U.S. Department of Labor, under the new administration, is looking at bringing AB 5 to Washington to make it federal legislation. Now,
wow,
we're,
that was
we're,
gonna be my
we're,
that was gonna be my
we're
question, is how
yeah,
does the AB 5 have legs? How soon is it going to start to trickle? Kind of like most things when it comes to legislation and stuff like that. A lot of times it starts in California and then it comes on across.
Well, usually it starts in California, and we can't stop it given the politics in California. But traditionally, it doesn't necessarily break along party lines in Washington. There are certainly pro business Democrats who uh, who will listen to the issue, but it's high enough on the administration's priorities that it's perking around in the House in legislation that would be advanced very quickly, particularly if the elections in November uh, meant that the Democrats had a majority in both the House, Senate, and the White House. So that's how close this really is to drastically changing the complexion of trucking as we know it because of its effect on the independent contractor model. It's interesting to note that ATRI, which is the American Trucking Association's research institute, says that there are two different models for what could only be qualified as excellent truck drivers. One is someone who enjoys the regularity of a 9 to 5, uh, being at home, have set wages and benefits, uh, and is happy to uh, follow orders and live within a confined income. The second breed is folks who are looking for an entrepreneurial opportunity, who are looking to set their own wages, who may have more of an entrepreneurial spirit. That second group of people it is largely dominated increasingly by first and second grade immigrants and minorities and all kinds of different people who are united in the fact that they want to be small businesses, and this is the way that they choose to do it. So a lot of the studies suggest that contrary to what you'll hear on the news broadcast, the idea of making everybody an employee and forcing up benefits will lead to more truck drivers uh, is a false analogy. That if people wanted to work a 9 to 5, they would have turned in their trucks a long time ago. That where the problem is going to come is what do you do with the some say 800,000 independent contractors? Uh, how do they keep the benefits of being a businessman if there have to be accommodations to AB5? In that
So was
regard,
this was this maybe an effort to kind of go after like the FedExes of the world and FedEx Grounds of the world that utilizes has a major national fleet that utilizes contractors? Was this something to maybe try to target them specifically, or people that operate under a similar business structure as them, operating structure as them, or is this just something that they were just trying to catch? Um,
unfortunately, Rico, in California, I'm getting reports of them going after guys who have 2 and 3 trucks and finding them as much as $187,000
Good God.
because they have tried to separate out their uh, themselves as independent contractors. Now, you've got to realize, give them credit. A part of their understanding is that when a guy is classified as an independent contractor and paid on a 1099 without withholding, there's certainly a lot of guys who forget to file their returns. There's certainly a lot of people for whom that entrepreneurial opportunity may mean they just don't file their taxes. And
Oh,
so, obviously, if you're in a broke state like California, if a guy's got a job and making a money, you want to be sure he gets taxed. Now,
okay,
if
Hank.
he doesn't
You,
have
you
a
you
job,
just
support him.
you just said something that made my antenna go up a little bit, and so I'm gonna bring this. I'm gonna ask you this question, and I think that it'll more of our audience may be able to relate to this question, and I don't know if you can answer it or not, but I'm gonna throw it at you anyway. Um, in our industry, especially smaller guys have one, two, three, four trucks, maybe even five trucks. A lot of times they have drivers and they pay them. Uh, they don't necessarily. There's not a true lease per se. They're really an employee, but they pay them via 1099. They pay them a percentage of gross revenues or whatever however their structure is, but they pay them on a 1099 versus a W-2. Um, what are the ramifications if a small guy out here is doing something along those lines? That's the way that they're kind of operating their business structure right now because they're trying to avoid. I don't want to say they're trying to avoid unemployment taxes and stuff like that. But of course, if you're paying a person on 1099, of course the unemployment taxes and everything you're kind of skirting by on not having to pay any of that type of stuff, and also workers' comp, which but a lot of times, especially in the South, you don't have to worry. Workers' comp is not a big of an issue if you're under, I think, three trucks in certain states. Certain states, as long as you're under three trucks, you don't have to worry about a workers' comp program or something like that. But a lot of people that I know personally have employees, have trucks, have people in the trucks, and they're paying them via 1099 versus a W-2.
The very simple answer to that question is the carve out is based upon the independent contractor agreement and the owner operator justifying his independence because he either owns or has ownership rights in the truck. Say, for example, here in Tennessee, we have a carve out in the statute that says if you're an owner operator, you're an independent contractor. I have clients who I just trust didn't know any better and thought they had the option to pay a driver on a 1099 and not worry about withholding. But that does not pass smell test. That will in California get you taxed retroactively for all the nanny state benefits that you would have had to pay if you had properly classified him as a driver, as an employee driver.
So
So
so it sounds like that's what it sounds like that's what they were trying to combat in a sense. The people that have been getting by on skirting by paying employees on 1090, rightful
yeah,
employees.
that may be true, although if that was their goal, they didn't go after it very surgically because the way they've passed it, it's going to get the guy who owns his own equipment and
Right.
elects to take the benefits. You don't have that election under the nanny state rules. Now, if you're an independent contractor, as I am, that I have an LLC as a law firm that my income comes based upon it's irregular. If I win a big case, hey, it's a happy day. Otherwise, I'm floating my own. But
Right.
when it comes to health care and those kinds of things, I'm not subject to the workman's comp. And most owner operators in states that have workman's comp laws are advised by the carrier to get occupational accident. Okay,
Right.
nobody really suggests that you ought to bet with the unlimited healthcare cost in order to be an independent businessman. But the fact of the matter is that you can get roughly comparable OC Act a whole lot cheaper than the workman's comp tear because the workman's comp rates in most states is far higher. Now, one can say there are different reasons for that. They can say that the independent contractor is less liable to take a free vacation because he gets in the truck and drives. I guess the issue becomes: is he forced to drive, or is it that entrepreneurial zeal that says he wants to work get the job done and not be a malingerer. That goes both ways. Okay, I'm not saying that one is necessarily right or wrong. I'm just saying it ought to be a business choice. And anybody that tells you that a truck driver with a good driving record can't get a job as an employee driver probably hasn't been out there very much. Two models run side by side, I believe, and I think they should. But uh, so hopefully we've set the stage for what AB5 is about. It would completely, if it came to Washington, it would completely do away with the owner operator independent contractor model. And so what people are trying to figure out is what are the alternatives. And I've got a being asked almost daily by clients that either have California domiciled equipment or run out there a lot. Hank, what's your best advice? And that's something here that uh, I guess the best advice is surrender and stop serving California, because that's about the only way that somebody can guarantee in that state that a driver will be considered to be an independent contractor under any of the other five uh, issues that have been suggested. So, if there are any questions, just interrupt and we'll take them while we're going, because otherwise, I'm going to consider what are the five or six most topical ways to avoid AB5, and we'll talk about where follow the money, who ends up paying for it, and how much. So,
Okay, yeah, let's do that, and then we'll shift gears back over to you filed some comments on the dispatch. Was that the dispatch service issue
yeah,
that you filed comments on?
yeah, we
So
filed comments on that on behalf of a dozen trade associations. Uh, if you're interested in this topic, and I think some of our listeners will be vitally interested if they're running California and if they're independent contractors or hire independent contractors, some you may just say, well, what's this going to do to overall freight? Okay, so there probably is no foolproof answer to it other than stop serving California. Okay, but one of the things that most people are trying to do as a protection and considering is what they call a corporation to corporation exemption. Now, many people say that that will not ultimately apply in California, but the rationale is that if the guy who's now paid on a 1099 uh, even though he has skin in the game, were to incorporate and set
right,
up an LLC or a sub S, then his LLC or sub S could sign an owner operator independent contractor agreement and make warranty to the motor carrier that he would comply with all federal and state law. Now, from a carrier point of view, that offers some protection because they could then say, well, look, I hired a corporation. Why should you discriminate against crescent carriers and say that Mr. Mohammed can't be treated as an independent contractor, but we can go out and hire a JB Hunt fleet?
right.
It is. So, I mean, there's good kind of equity in that argument. The problem is then you have probably the carrier has probably shifted the burden of compliance to the LLC. That may make the carrier feel a whole lot more protected against wage and hour suits and funny business such as that. But then if those obligations, state nanny state obligations, imply to crescent carriers, that's where people are worried. Well, now is state of California going to come in and and chase an independent contractor who just didn't have the money to get the workman's comp or thought he was crazy? So, the problem with it, a lot of people say, is it's going to almost need to be a trust but verify. If you are a motor carrier with owner operators and you're urging people to set up their own corporation, can't control how the guy does it, but you need to be sure that he understands what he's getting into and he does it right, because you don't want to set him up for being sued. He's
Right.
your business partner. Now,
Right.
then if that model is to really work, there have to be third party providers who come in and make compliance simple and easy. Typical owner operator uh, uh, finds great comfort in the fact that uh, uh, a lot of the accounting and that kind of stuff, the withholding and those kinds of things, uh, safety is taken care of by the company, and they'll have to do more. Uh, the 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 other issue, the second form, and this is one that if you read my book, uh, talking about in 2016, because this issue goes back that far. We're now 6 years in percolating this issue in California. And back then, we were talking about an alternative model in which a motor carrier, if the owner operator model became toxic in California, could set up an affiliated brokerage or freight forwarder and hire guys who were previously owner operators, but now who obtained their own authority under leases. Uh, Now, that is still something that's being looked at. The argument, of course, that is made by uh, people who are setting up affiliates is, we're not in the same trade of business. This company is a broker and ought to be treated just like C.H. Robinson and everybody else. It finds freight and gives freight to guys who are now legitimate power only carriers or full service carriers. Uh, that model would probably be pretty helpful to guys who want to get their own authority, because somehow there is a greater acceptance that an asset based carrier can and will treat power only carriers with a more understanding attitude towards getting miles and getting home than maybe the transactional brokerage. But that 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 issue has its problems too, and it really is, how do you uh, be sure that you're putting burdens of compliance on independent contractors that they can meet, and that you're getting additional revenue to them to uh, still make that a valid entrepreneurial opportunity. So, the broker or forwarder model is not by any means dead. There are a lot of large carriers who see a need to deal with the tension, and the way they're dealing with the tension is to put in uh, uh, trailer pools. And so the whole idea of power only uh, as a way to help increase productivity has some appeal. So
Would that chapter? What chapter would that be? Would that be considered chapter 8?
uh, I've got the book here. If you give me a minute, I can find it. Let's see if there's another question uh, from the
Well,
audience. And I'll
Stephen had a question. Wanted to know whether or not if your book was available like for e-reader or Kindles, or is it just or is it just the physical copybook?
uh, we could probably we could probably send somebody a PFD of it. We don't have it on Kindle or anything such as that. Uh, the hard copy is probably the way we've traditionally done it. I'll be happy to send Steve a copy and see if he has problem with it. The first book, which was a
Right.
smaller, it's called Protecting Motor Carrier Interest in Contract.
That's right.
We
That's
we
the
do
one.
have that in a PDF format that's fairly user friendly. This chapter is in the back of the chapter that talks about preferred affiliates in MAP 21. It says it's under outsourcing truckload freight, and MAP 21 is really where we talk about the freight forwarder model being a preferred option for
Yeah, that's chapter
outsourcing
8.
freight. And
Yeah,
that's
chapter
really
8
what
is
we're talking about doing.
outsourcing.
Yeah, for carriers who have commitments to uh, facilitate spikes in transportation and don't have trucks, obviously need to be able to bring in excess capacity. So the whole idea of having excess capacity available is something that I would argue a motor carrier shouldn't be deprived of. You shouldn't have to go to uh, a broker only when the most dependable freight is probably to get a good seam on regular freight, particularly for carriers that have peaks and valleys, end of the months, the runs, and establish a working relation. That's obviously part of what you've always preached, Rico, which is get a dependable customer, get in a traffic lane, try to get some balance,
Right.
rather than just be subject to the fact that you got to get permitted in 48 states and you're here today and there tomorrow.
Right.
So,
Right. So
uh,
I'm sorry. Go ahead, Hank.
no,
You talk.
I just wanted to go on to the next one of these, which I call the pool pedal theory. And what I see some carriers doing, particularly if they serve that long haul lane to the West Coast, is saying, well, I'm going to pool my freight as far as Nevada or Arizona, and then hire somebody else who's California uh, compliant to haul it into the state. It's kind of like having a statewide cartage agent. You
Right.
pay somebody. If you got a through trailer movement, you may just interchange it. If you've got distribution freight, uh, my clients that otherwise might pedal California uh, on a multiple stop basis will say,
Right.
"Listen, let me take those six deliveries to Sparks and give them to some." You might want to call them an agent, but these guys are actually licensed, authorized, and insured carriers to make that move. And I think that has some real sense. I think we all know that one of the largest truckload carriers who uses independent contractors, when it looked like AB5 was coming down, just said, look, if we got California domiciled independent contractors, they need to move outside the state. I mean, those sound like they're fairly draconian, but I think that in part is the reason that you've got such a great increase in the number of applicants with the FMCSA. So,
Okay.
how far that'll get, I don't know. But obviously, if there's going to be a 30% increase in the cost of labor in California for those kinds of people, uh, that increase in cost can't be very easily absorbed in the existing rate level. So what you
Right.
may end up seeing on rates and lanes is that when you're talking about the average rate out of out of the southeast, you may have to put in an exception for the California surcharge.
Got
And
it. Got
I think you really need to think about it. In the old days, the LTL carriers all had bureau rates, and they all had accessorial charges, and they all agreed that to cross into Manhattan was a hassle, so there would be a New York surcharge. Well, clearly, California, with its nanny state attitude, has taken the cost of operating there through the roof. And if you're perfectly allocating costs and it's being compensatory, then your freight ought to cost a little more in California. So
got
that
it.
that's another way to do it. And I think we've got one more uh, prototype that's being tried. It's called the two company, two paycheck method. And what it
Okay.
basically says is the carriers are looking at hiring the drivers and paying the drivers in accordance with California law. But at the same time, uh, taking the guys who are owner operators and saying, we will lease your equipment and pay you uh, your percentage or your mileage to encourage your productivity. So what they say is, well, we'll accept either directly or indirectly making the nanny state payments for you, but you'll still have the entrepreneurial opportunity to depreciate the value of the truck, uh, to run those extra miles, to make more than the standard stiff, you know, with his hands on the shovel, waiting for the rest break. So the idea about this split model is to not completely kill the entrepreneurial venture. Uh, the some people say, "Oh Lord, we don't want to do that. We sure don't want to admit that this truck driver is an employee because that'll just uh, lead to less productive employees, uh, uh, possible unionization, into more of the typical problem that uh, people who are looking for folks that want to get miles and get home would then say, well, gee, I'm on the clock and overtime's here. So there are problems there. Some people are trying to address this by using third party entities as statutory employers. This is really nothing new. Uh, it's been around for years with NICA and CMS, that you'd have basically a payroll service for owner operators. But that is one option that is being explored to put that employee one step removed from the carrier, with a third party ensuring that the taxes are all properly filed. And I think the people that are looking at that model want to be very pristine about their contracting practices and want to be sure that they're not the object of a California Department of Revenue suit. So
That's
those are basically the six things that are being conjured up. And I guess the question is, nobody can guarantee any of them, but anybody with California domiciled equipment is looking at some way to hedge his bets.
okay. That's interesting. A lot. That was a long way around to get to, uh, to try to make this thing fit this square peg into this round hole is what it ultimately seems like on my end. But I'm just I'm
Well,
just a small.
it is, and the problem is you've got what for many people is an unfair and destructive law. If you suck the independent contractors out of the over the whole trucking, God knows what kind of problems we're going to have. But from the point of view of someone who believes that the employee model is a public right, any alternative we come up with is going to be looked at as a subterfuge,
So
a way,
maybe to kind of put
way
a
to
little
get
bit of
around.
so maybe to put a bow on the issue as far as the AB5 issue is concerned, and things like that that may be coming across, coming to a state near you, or maybe coming to your state, is for us to ultimately on a grassroots level make sure that we're staying actively engaged with our elected officials, and maybe writing or talking to calling our Congress or senators to make sure to at least let them know that there's some resistance out here, that they just can't rubber stamp this thing on us.
Well, I think that it's important that uh, the politicians understand that the people that don't support AB5 isn't left to, like you say, the FedEx. Okay, uh, because let's face it, Amazon is the poster child for abuse when it comes to this. And if you watch late night TV, you'll see that it's always a disgruntled Amazon employee that is singled out. Bad facts make bad law. What they need to hear is from uh, the guy whose wife keeps the book. He drives one truck, and his brother owns a truck that otherwise is going to be subject to the nanny state taxes. Uh, the point has to be made that it's an industry problem and not just some way to abuse the working man. And that's one of the reasons that I'm urging smaller fleets and independent contractors to, sign at least sign petitions saying that AB5 makes a wreck out of the idea that they ought to be able to drive from one coast to another and be treated as an independent contractor. Uh, in that regard, Lord knows with all that's going on in Washington and all of the problems of protesting and those things, I don't want to come across to anyone as advocating that, but it kind of brings a smile to my face when I get up in the morning and realize that Oakland's having its problems with independent contractors who are saying that they oppose AB5, and I just wonder how long the people in LA and Long Beach are going to be able to ignore the elephant in the
Okay,
room.
Hank. Right, right. Well, look, we got a little bit more than 10 minutes left in the show, and I want to make sure that we touched on and circle back around to the whole dispatch service issue. And last we talked, we kind of had a deep dive discussion on it the last time that you were here. But since then, you filed comments. You want to share with us how that's coming along, or what's the status?
Yeah,
Give update on that.
there were a number of comments filed, and we've gotten some kind of amens from some of the other people. Uh, in this one, usually we have half a dozen or more trade associations that join in. In this one, we had a baker's dozen. We had 12 or 13, and the participants weren't just motor carriers that were affected. It was a lot of trade associations, including NASTIC, that represented small carriers. Uh, the issue, as teed up by the proponents, was that notwithstanding what the law says, that if an intermediary doesn't handle the transaction of the receivables, it's not a broker, and that anybody that wants to call themselves a dispatch service should be able to go to the call boards and solicit freight for 1,500, however many it is, carriers, as long as they are the money is funneled through the small carrier. Well, we pointed out that to deregulate the definition of a broker would leave these middlemen out here without any accountability whatsoever. And we said, look, agency, it's well settled that if you're arranging for transportation for compensation, and you can play bait and switch on what the name of the carrier is. You're setting up uh, vicarious liability. You're setting up people showing up and hauling freight that don't have any authority. We've already got enough fraud problems uh, with the small carriers getting hoodooed by folks that are going to cheat them out of the money, get factored advances, doing all kinds of things. And we tried to bring that home in two different ways. Number one, we went through all of the regulations that apply to broker and broker abuse, including the right of private action and including the right of the government to get fines for them, including the obligation not to take kickbacks, all of the other things that weren't addressed. And we said, if you deregulate these people, you're going to strip the motor carriers and the shipper industries of these rights. And then in the end of it, we said, look, you ask us in question number 13, what should we be doing? And here's what you should be doing. You should be enforcing the rules as they are. And we offered three examples of abuses and where the agency had authority hadn't done anything. One example involved 15 loads of stolen copper wire in an obvious broker fraud of reconsigning copper shipments to Chicago from which they were lost. One involved a broker abuse situation in which the same gentleman in California in the same month set up both a broker in Rancho Cucamonga and a carrier in Diamond Bar, two towns out there in California. He took the loads in the carrier's name, brokered them through the broker's name to unsuspecting carriers. When his bond was closed down, there were 143 carriers filing against a $75,000 bond, and they all got 40 cents a hundred. Meanwhile, all of this was reported to the FMCSA. They have a record of it, but they haven't chosen to do anything with it. In fact, one guy wrote me a thank you note, and he said, "Look, you may not know, but we went to the FMCSA and told them that they should be enforcing it. Here's their letter that said go see the postal inspectors." And that's really kind of humorous. The postal inspectors, bless their soul, are not the most active or knowledgeable people when it comes to broker fraud. And
so a couple of questions then, Hank. Um, is there a date when they're supposed to rule on this whole situation as far as the dispatch services are concerned?
no, there is no deadline. Uh, there is an unconfirmable rumor that they're probably not going to come out with anything until after the fall elections. That if the fall elections indicate that they're going to be able to run the table, that you may see a new SMS methodology rulemaking and a rulemaking on out of the Department of Labor on AB5 come before Christmas. Uh, there's no time limit on this other one. Uh, I think there were enough people uh, filing comments contrary to this that there's obviously no constituency that they need to pander to. So I don't see them coming out with anything quickly on that. If
And so,
anything, if anything, I think the uh, uh, the extent to which we highlighted abuse would stand out as a real contradiction of any rule they wanted to make. They'll have to go through rulemaking to change the current definition of a broker, and that means they've got to have considered all of the comments. And I don't think they relish dealing with the extent of the real fraud that's out there. I can say this also as another issue: if they're people listening on the line that have uh, broker problems and bad debts, you ought to jump on the bond and file it quickly. Uh, the
Don't wait. Don't
well,
wait.
yeah, I'm looking at, and I love y'all's feedback. I'm looking at doing a webinar on. Uh, Maybe I'll borrow your stream here one night on how to better protect yourself in the spot market. Uh, One of these cases involves uh, at least 75 motor carriers uh, that sign contracts. It said on the front page, you'll look only to the broker for payment of the freight charges. Now, if
that was a red
well,
flag
yeah, I
right
mean,
there.
if you, well, I mean, CHR and everybody else puts that in there, but ultimately, you got to ask yourself, why am I giving up recourse to the shipper if this guy's been in business 2 months? And then in one of these cases, the bills of lading that the carriers were picking up said send freight bill to a legitimate broker, and said name of the carrier is the identified carrier that the broker handled. Now, if you go pick up a bill of lading and there's a stranger as the bill to, and there's some carrier you had no relationship that shows as the guy who's supposed to make pickup, then what is a wise man to do? Well, I think number one, it is you're required by the statute to give a receipt. The receipt should at least have your name on it to establish you're the dude that picked it up.
Custody.
If you pick it up and don't sign the bill of lading with your own name on it, I don't think you got a very good case for saying you've got a contract with the shipper. And then the other thing is, you have got a lien, possessory lien for payment of freight charges that you give up when you deliver the thing. So, if you're going to smell out a fraud, you need to smell it out before you deliver the load. And those are just basic things. Uh, we've been making a little study, and everybody seems to agree that somewhere between 60 and 75% of the truckload shipments are picked up and delivered without the name of the pickup carrier.
Right.
That is
I
just
think that we definitely should. We definitely might need to explore that, Hank. If you want to do that, I definitely would be interested in assisting or hosting or whatever. We can definitely, because I think a lot of times we've talked ad nauseum about making sure you can get your name on the bill of lading and stuff like that. But a lot of times, I think for newer people or people that maybe not um, unfamiliar with how all of the mechanics of this stuff works, it would definitely be beneficial for them to maybe to see that in a black and white PowerPoint presentation or whatever, however you wanted to try to
well.
pull it
I
off.
think I think it needs to be done, and at some point, rather than have this standoff between carriers who've been defrauded and shippers, I would think that the shipper should, if he's looking to the broker to vet the carrier, should at least be sure that the vetted carrier is the one who makes pickup. Now,
Right.
if somebody's played bait and switch and you've given it to, and I've had these, given this to people that had revoked authority and 18-year-olds behind the wheels, where are you in defending that? I think that the shipper's got some culpability, as I do the shipper who had expensive copper wire and gave it to 8 different carriers, none of whom were named on the bill of lading.
Wow. So another question, Hank, would be I'm not sure. This might be. I'm not sure if you can even answer this one because we don't have anything concrete as far as um, a law or anything is concerned. But do you anticipate if some type of regulation or anything was passed, would it have any teeth to it? Would it, as far as if someone were to get caught doing this, is there what kind of ramifications or remedies would there be under the law? Do you think
Well,
might be coming down?
that's a good question. What we tried to remind them was that there's already a federal statute on the books that says two things. One of them says that any carrier or any member of the public who is injured by the failure of a carrier or a broker to fulfill their duties has to compensate the victim and pay his attorney's fees. So you've got the right of private action now. But where that's really enforced is in another statute that says that the FMCSA can bring its own cause of action against someone for violation of the broker regulations and can impose a penalty of up to $10,000 per violation, not only on the broker, but also the owner of the broker or any other party that's involved in the scheme. So, I mean, you've already got legislation that is
Okay.
wonderful, but what we don't have is we don't have an agency that has any
To
concern.
enforce it.
They have no enforcement people, and all of their people are trying to figure out how to get around to look at 100,000 new carriers and certify them as safe. The government is throwing away money like it's going out of style. What we are probably going to propose is, look, if it's not a federal motor carrier safety administration's duty, then take the OIG or some other department within the Department of Transportation and give us some investigators. They've got an obligation to fulfill the national transportation policy, which says that they're supposed to encourage competition in the workplace, fair dealing, and fair treatment. We've got a thing called the Federal Maritime Commission, which does that. They have proceedings. They'll prosecute steamship lines for abusive procedure. They feel as though their mandate goes beyond being sure that a ro-ro ship doesn't roll over. And
Man,
what we're saying is that's an exclusive province of the federal government under the Commerce Clause. They should be exercising it.
I tell you, Hank, every time we have you on, it's always fascinating, and the hour just goes by completely too fast. I just want to remind everyone. I'm going to share my screen again. Once again, we'll go to Hank's website. It's www.transportationlaw.net. As you can see, I'm sharing the screen right here. This is the ways you get in contact with Hank. If you got questions or if you want to have your own agreements or anything like that drawn up, this is how you reach out to Hank. You can find him on the website. All the contact information is there. If you want to order your book, the book that we was talking about, the book that I have right here, if you want to order your book, Rules of the Road, a practical guide to legal issues in the trucking and transportation. If you want to order your book, you can do that on that website. You get your physical copy, and Hank say he may look at making a PDF or something like that available. But I say go ahead and order the book, get your book. Order two, keep one in the truck, keep one at your desk.
Yeah, but if one gets more, you'll have one left over, right?
Keep it with you. But I tell you, so once again, Hank, I want to definitely thank you for being so gracious with your time, coming on and sharing with us and explaining some of these complicated issues, breaking them down to a more layman's term so that we, the small guys, can understand them. Because a lot of, us small guys, we don't have a legal department. We don't, and you have been great with helping us kind of navigate our way through some of these different things, that issues that we definitely have that come up from time to time. So I definitely want to say thank you, and we definitely appreciate you for taking time out to do so. And keep in mind, if you want to do that webinar or whatever, just let me know. We definitely,
all right.
no matter.
We'll set that up. I may do it for another trade association and just put it on. If you help me with the YouTube, I may just throw it up there.
Absolutely, there's no problem at all. We'll definitely make sure do whatever we can to help out. So with that being said, ladies and gentlemen, we want to thank Hank again for coming on, joining us. This has been another episode of the Rates and Lanes podcast. I have been your host, Rico Muhammad. That is our special resident legal expert and guest, Hank Seaton. I want to thank you guys for taking time out to watch. If you're looking at it at a later time, thank you as well. Be here same time, same place next week. I'm not sure. Got a couple of different people that we're working on as far as guests are concerned. So we shouldn't have a better indication on that later on this week or earlier part of next week, Monday of next week. But until then, ladies and gentlemen, stay safe out there, stay healthy, keep it in between the mustard and the mayonnaise, and God willing, we'll talk at the same time, same place next week. God bless you.
Night all.